Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, it is Thursday, June 1st, and many of you woke up this morning as felons. Well, maybe or maybe not. Now, we're talking about the pistol brace rule, and what we're talking about is the application of the injunctions. Now, as we know, there's been a lot of debate because of some pretty bold claims made by the Firearms Policy Coalition that being a member of them would allow you to enjoy the benefits of the injunction that was issued in Mock v. Garland. Now, there was some skepticism about that, myself included, and the reason being, of course, is that when something sounds like it's too good to be true, well, it probably is. But there is another case kicking around in Texas that involves another organization, which I'm a huge fan of, and that is the Second Amendment Foundation. And I think that the order on the injunction there actually clarifies things, and for once, I may actually have some good news for all of you. So, today, let's spend a few very important minutes and get you all up to speed on how avoiding the pistol brace rule really might be this easy after all. Okay, for the 234th time, we are talking about the pistol brace rule today, but instead of talking about the case of Mock v. Garland, which we've spent a lot of time talking about, I want to actually talk to you about the case of Second Amendment Foundation versus ATF. Now, that is filed in the United States District Court, North Division of Texas in the Dallas Division. Now, as you know, the good folks over at the Second Amendment Foundation, another organization I feel very, very strong about. And so what I do want to kind of preface all of this is, listen, whether or not you're going to get an injunctive relief by joining the Second Amendment Foundation or the Firearms Policy Coalition or the Gun Owners of America, or any other worthwhile organization out there fighting like holy hell for your rights. The bottom line is you should be supporting these organizations no matter what. The bottom line is you should have already had some skin in this game. If you are just now awakening to the fact that membership in these organizations can have some incredible benefits to you, well, welcome to the club, and let's get signed up today. And I'm going to put the links if you guys want to join Second Amendment Foundation or the Firearms Policy Coalition or the Gun Owners of America. I am going to put links for all of that down below in the description box. But here's the deal. Is in the case of Second Amendment Foundation versus ATF, the plaintiffs wanted a motion for clarification as to what does the injunctive relief mean here. Does it include all of the members of the Second Amendment Foundation? The court has issued its ruling, and I think there is a lot to take from it. The bottom line is does this injunction cover Second Amendment Foundation members? Yes, it does, and it does so because the court here is of the opinion that the Fifth Circuit's injunction did in fact cover all of Firearms Policy Coalition's members. Don't believe me? Let's take a look at what the order itself actually says. Before the court is plaintiff's motion for clarification of the court's May 25 preliminary injunction order. In their motion, plaintiffs asked the court to clarify that the court's preliminary injunction order applies to both the Second Amendment Foundation Incorporated and its members. The court grants the motion and clarifies that the preliminary injunction order in this case applies to both the Second Amendment Foundation, Inc. and its members. On May 25, 2023, the court entered an order based on the Fifth Circuit's recent unpublished order in Mock v. Garland. In Mock, an emergency motions panel for the Fifth Circuit granted a preliminary injunction pending appeal, but limited the injunction to the plaintiffs in that case. The plaintiffs in Mock are two Texas residents, a firearms and firearms accessory manufacturer and retailer, and a member-based nonprofit organization. In a subsequent motion, the Mock plaintiffs asked the Fifth Circuit to clarify the injunction's scope. After briefing, the Fifth Circuit granted the motion for clarification. The Fifth Circuit clarified that the injunction pending appeal also applied to the plaintiff organization's customers and members as well as the individual plaintiff's resident family members. The court further indicated that the purpose of this clarification was simply to preserve the status quo ante for the parties and persons within reasonable scope of the motion panel's injunction pending appeal. Here, the court's preliminary injunction order likewise limited the injunctive relief to the plaintiffs in this case only pending resolution of the expedited appeal in Mock. Thus, consistent with the Fifth Court's order on clarification, The court clarifies its order to confirm that the preliminary injunction entered in this case provides relief to both SAF and its members. Here, SAF is suing on behalf of itself and its members. Accordingly, staff members are reasonably within the scope of the court's preliminary injunction pending the mock appeal. A preliminary injunction to the contrary would fail to afford complete relief. Accordingly, the motion for clarification is granted and the court confirms that its preliminary injunction applies to both SAF and its members. Okay, so now we have a second court of law reviewing the Fifth Circuit Court's injunction and saying, hey, you know what we're going to do is we're going to do the same thing here that they did in the Fifth Circuit. And what we believe they did in the Fifth Circuit is that the people who enjoy the fruits of that injunction does include all the Firearms Policy Coalition members. Likewise, in this case, Second Amendment Foundation v. ATF, the court has very wisely and correctly ruled that since the Second Amendment Foundation is a named plaintiff and they are suing on behalf of all of their members, that the injunction in SAF v. ATF applies to all Second Amendment Foundation members. So, whether or not these injunctions extend beyond the scope of the state of Texas or the Fifth Circuit is a whole nother video that we will need to do. But yes, does it appear as of today, Thursday, June 1st, that being a member of Firearms Policy Coalition or being a member of the Second Amendment Foundation, both incredibly worthwhile organizations to begin with, will actually get you enjoined from the pistol brace rule according to two courts now? The answer appears to be yes. We will obviously keep you posted on this. We think there's going to be perhaps some more developments. We know that both of these cases are being put on expedited oral argument schedules. So oral arguments are coming up this month. We know that the United States government is going to completely crap themselves over this injunction, and there may be further litigation related to that. If there is, you will be the first to know. In the meantime, if you guys got any questions about the pistol brace rule, the injunction, or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. But if you don't, that's okay, because that information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.